Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
It's the second Saturday of the month of May in the year 2026. And I am so excited to welcome you to another edition of The Community and the Law. How do you meet the financial requirements for UK spousal application if you are self-employed? We'll be looking into this, so I am inviting you to join us whilst we go live, and then also ask you to invite other people to join us. My name is Oreku Frimpong, and this is The Community and the Law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
once again, and welcome to another edition of the Community and the Law. Lovely Saturday afternoon here in London, and we bringing you something that will make the afternoon so very nice and memorable. This afternoon, by courtesy of BWF Solicitors, our proud sponsors and benefactors, we bringing you another discussion that will help you, especially when you put in an application. This time we're looking at those who are self-employed. And I'm asking, how do you meet the financial requirements for UK spousal application if you're self-employed? Our resource person and guest this afternoon is Lawyer Charles Asma from the stables of BWF Solicitors. BWF Solicitors is a trusted partner when it comes to the law. They are located on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them, book an appointment, see any of the lawyers, and present your case to them, and they will definitely give you an ear and also help you navigate that cause. 0208 493 7340. The number again, 0208 493 7340. And those of you who are in Ghana, BWF Solicitors has an office in Accra, and you can reach them on 055 589 5959, 055 589 5959. In all situations, emergency situations, you want to send a text, you want to reach them out on WhatsApp, and at any time, just call the UK number 077 127 61884, 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. They help us with immigration issues, nationality applications, appeals, divorce and marriages, what it is that you can do with those situations. When it comes to employment, they are on top of it. And of course, with business development as well, you can trust BWF Solicitors. I will tell you where they are again: 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. Call them once again, 0208 493 7340. The number again, 0208 493 7340. And in all emergency situations, you can send a text, WhatsApp, or call 077 127 61884, 077 127 61884. Now, on a Saturday afternoon, we bring you the Community and the Law, and it's live on BWTV, and we stream live on Facebook and YouTube at BWF Solicitors and at BWTV. We have welcomed you into the month of May 2026. Yes, and we're moving and soldiering on for God's country, and of course, somebody will say survival. But what we do at BWF Solicitors, the preceding month, we look at what everybody does, and we get staff to vote and select the employee of the month. Last week, I mentioned it, and I want to reiterate it and say again that our employee for the month of April 2026 is Helena Asma, a paralegal here at BWF Solicitors. So, ladies and gentlemen, join me in congratulating Helena Asma. In fact, she happens to be the latest addition to the BWF Solicitors family, and we acknowledge the fact that she puts in a good effort to make sure that we give to our clients the best of service. So, Helena, thank you very much. Keep doing what you're doing. Keep soaring high, and I believe you will be a good support to the community as you have started. So thank you, Helena. Thank you, BWF Solicitors, and thank you all those out there for helping us acknowledge the efforts of Helena Asma as our employee of the month, April 2026. There's an update that came earlier this month on the 3rd of May 2026. The BRP rule changed, and there is an important update to that. As confirmed in the guide, AN Naturalization Guidance from the 23rd of April 2026, you no longer return your BRP to the Home Office. Instead, once your naturalization is granted, you must destroy your BRP yourself, including cutting through the biometric chip and key security features. Now, failure to comply may lead to data security risks and potential misuse of your card. So what do? If you have recently naturalized or you are about to, ensure your BRP is securely destroyed in line with the updated guidance. What are they asking us to do? You cut through the biometric chip and also cut through the security feature so nobody can use that. So follow that protocol and get that sorted. BWF Solicitors will provide immigration advice, specialist immigration advice. They want to keep you compliant, and that's why they have brought you this one to keep you updated. So please remember, when you go for your naturalization or you're about to, you don't need to return your BRP card to the Home Office. Now they're saying it's your responsibility to destroy it and put it away, throw it away. How you do that is just to cut through the security chip and also through the security features that are on the card, and then throw them away. So thank you for that. If you need any further advice on this or some further information on this one, call BWF Solicitors on 0208 493 7340, 0208 493 7340. Those of you in Ghana, 055 589 5959, 055 589 5959, or emergency situation 077 127 61884. Or you can visit any of the social media handles, Facebook, TikTok, YouTube, and all the rest at BWF Solicitors, at BWF Solicitors. So yeah, that's an update for you, and I believe you take note of it. And if you need any further assistance with all these things, just call BWF Solicitors, as I have indicated earlier on. Now, I say, and I want to reiterate, that BWF Solicitors, they help us every week with something that we can chew on, something we can add to our repertoire of knowledge, and enhance, of course, embolden ourselves when it comes to the law. Now, we're talking about employment here, job offer that's been withdrawn. Can you have a claim on that? The decision in Kankalapali versus Lonche Energy Systems Limited confirms that accepting a conditional job offer can still create a binding contract. Even if you haven't started work yet, your employer cannot simply withdraw the offer without consequence. I want to say again that accepting a conditional job offer can still create a binding contract. Even if you haven't started work yet, your employer, or potential employer, so to speak, cannot simply withdraw the offer without consequence. What does this mean for you? You may be legally entitled to notice pay. Conditions like reference and or probation may not prevent a contract forming. Then, withdrawal for internal or business reasons may also be unlawful. So if your job offer has been withdrawn, you could be entitled to compensation. If you want further advice on this one, I urge you to contact BWF Solicitors, your law experts, and also those who can really protect your rights. So remember, job offer withdrawn, you may have a claim to compensation. You may be legally entitled to notice pay. Your conditions like references or probation may not even prevent you from having a contract formed. And withdrawal for internal or business reasons may also be unlawful. Remember, you could be entitled to compensation. I'll get lawyer Charles Asma to help us take this a bit apart and also get some clarity and more details on that. But before he does that, let me ask you to consider this scenario, to be fair. It's about Ali Samba. Now, Ali Samba's application for a project manager role was successful, and the employer sent him an offer letter by an email. This email said that the job offer was subject to receipt of satisfactory references, a right to work check, and a successful 6-month probation period, and proposed a start date of the 1st of April 2026. Check those scenarios critically well. He applied for a role, was successful, and the offer letter came via email. And it said that it was subject to receipt of satisfactory references, a right to work check, and a successful 6-month probation period. And then proposed that Ali Samba started work on the 1st of April 2026. Right, let's go. Ali responded and said that, well, he accepted the offer and promised to sign and return the documents in some few days. He then returned the requested forms, including copies of documents confirming his right to work in the UK. So, well, they gave him an offer, he accepted, it went on. On the 15th of April, 2026, around 3 weeks before Ali was due to start work, the employer told Ali that it wished to delay his start date to the 3rd of July 2026. Ali replied saying that he had already booked flights to the UK for himself and his wife and asked what pay he would receive for April to June. Because the initial offer, remember, said that he was to start work from the 1st of April 2026. Now they are saying, for some reasons, they're pushing the start date to the 1st of July 2026. A few days later, listen to the story quite well. A few days later, the employer emailed Ali confirming that it was no longer able to offer him the contract for the position of a project manager commencing the 1st of April 2026. The employer's reason for withdrawing Ali's job offer did not relate to Ali's failure to meet the terms of his conditional offer, job offer, so to speak. Rather, it withdrew the job offer for its own completely unrelated reasons. Now, Ali wishes to bring a breach of contract claim, arguing that the job offer had been withdrawn without giving him appropriate notice. Now, let's see what advice we can give to Ali on the chances of his claim. Would it be 1, Ali will succeed because the employer had breached the contract? Would it be 2, Ali will not succeed because the contract had not yet started? Remember, the offer was that he started on the 1st of April 2026. Later, they sent a letter to say that they would delay the start from April 2026 to July 2026. Later on, they said to him that, well, unfortunately, we can't continue with the job offer, so we're withdrawing it. Okay. Now, Ali contended that if you were going to postpone the start date from 1st of April to the 1st of July, when I had the offer, I made travel arrangements. I bought a ticket for myself, I bought the ticket for my wife, and we were coming to the UK before the 1st of April so I could start work. Now you say you postponed it to July. Am I going to receive any pay from April, May, and June? those 3 months, from April to June, am I going to receive any pay? Well, that was not responded to, but what they said to him was that, well, unfortunately, we can't continue with the job offer. So then he says, I'll make a claim against you. Is he going to succeed? Let's advise Ali. But hold on to that. We'll come back to this at the tail end of the program and pick up your answers. And then we'll run it by lawyer Charles Asma to see what answers were given and what answer was correct of the two. Ali will succeed because the employer had breached the contract. And the second one was that he will not succeed because the contract had not yet started. We are live on BWTV, and the program is The Community and the Law. Now, let me see those of you who have actually joined us online and pick up your welcome chats. And, well, we have starting Adele Safo saying very sunny Saturday afternoon. Yes, it's so bright and beautiful outside my window. I'm happy about that. I hope you are as well. Put your feet up and let's enjoy the program together. Please share when you join. Thank you very much, Adele Safo. Congratulations to Helena Asma for winning the Employee of the Month, and also thanks to BWF Solicitors for always updating us. Good afternoon. Richard Nanausu comes up with that one. Richard, thank you so very much. God bless you for joining. We appreciate you. Keep them coming through. We're live on Facebook at BWF Solicitors and at BWTV. We're live on YouTube at BWF Solicitors and at BWTV. The topic we're discussing this afternoon, how do I meet the financial requirements for a spousal application when I am or if I am self-employed? As I said, our resource person is lawyer Charles Asma, and he will be explaining this, taking us through that and some of the things we need to know and do. And we will be picking up your questions and concerns as well. The number to call when the lines are active will be 0208-493-7345, 0208-493-7345. Or you can send a text or WhatsApp to 07399-208-468. Alexa say, hi, thank you for joining. Well, ladies and gentlemen, let's all together go over and pay our tribute to BWF Solicitors. Say thank you to them for giving us this opportunity. BWF Solicitors are trusted partners when it comes to the law. We'll be right back.
From London to Ghana, yeah. BWF in the house, let's go. Integrity, excellence, we rise together. We stand with you. We stand with you. BWF, when the path is tough, we'll pull you through. From Seven Sisters to Accra too. We stand with you. We stand with you. On the high road in London town, 228 on a house we're found. And Christine the sound. Family, immigration, wills and probate, we're around. 30 years strong in the game. We got a law in our name. When life gets heavy, we lift the weight. Together we claim the fame. Oh, you want a dream? You need a team. BBUF by your side, shine like the stream. From Accra's Golden Dawn to London City Gleam.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hi, welcome back and thank you for sticking around. We appreciate you, and I believe that you will be liking the page, picking up the link and sharing, so those who are new will come and join us. So as a family, we do this together. Now, if you're new with us here, like the page, click on the notification button, and also get yourself ready for a lively discussion. This afternoon, we're looking at a very, very interesting and very important one as well. We're looking at how we meet the financial requirements for UK spousal visa application, and we're going to look at a scenario where we are self-employed. You know, obviously, when people get into jobs, either somebody employs you and gives you a salary or your wage at the end of a period, either a month or 2 weeks or 4 weeks, whatever it is that is agreed on in your contract. Or you're doing stuff for yourself and you pay yourself. So you do your expenses, profit and loss accounts, and all the other bits. So you declare what income or profit you've made, and based on that, you'll be taxed. We'll be looking at who is really self-employed, and in what circumstance do we even identify and classify ourselves as self-employed, and what it is that we can do with our finances, and also what we need to do to meet the financial requirements when we put in an application for our spouses to join us here in the UK. I mentioned earlier on that Loyaltas Asma is our resource person and guest from BWF Solicitors, and he's going to do justice to that very interesting and important topic. And then we'll also ask him to help us unravel the employment contract situation where we read and decided that we would give an advice to our friend who is facing that dilemma. He's been given a job offer as a project manager. He was given a start date of the 1st of April. The organization said we're pushing that to the 1st of July 2026, and he's asking whether he would receive pay for April to June, because what his anticipation was that he was starting work from the 1st of April. And then they come up again with the excuse to say that, well, unfortunately, we're not giving you the job anymore. And he wants to make a claim against the organization. Will they succeed or not? That is the scenario I have put before you. But let's now altogether welcome the resource person, a friend, and able solicitor, lawyer Charles Asma, to the fore. Asma, good afternoon once again. Sunny Saturday afternoon, lovely, 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 and I know we're going to have a very lively discussion. Good afternoon once again.
Ex-skilled worker dependent switched to 5-year partner route with a new British partner. The skilled worker's ex-partner successfully applied to switch to a new spouse visa as the spouse of a British citizen. Case overview. Our client came to the UK in 2023 with her husband, who was a sponsored skilled worker. Unfortunately, their marriage broke down because she met a new partner. The challenge: divorcing and marrying within a short time. Our client had received a letter from the Home Office stating that her ex-husband had reported that they were separated. She was given 60 days to switch her visa or leave the UK. She was advised that, as they were married in Ghana, she could file for divorce in Ghana. She followed our advice and obtained a court divorce from Ghana. She subsequently entered into a customary marriage in Ghana. Proxies represented her and her new husband. Once the marriage was registered in Ghana, she was ready to make her application without leaving the UK. Our strategy. As a result of the visa cancellation, our client needed to act quickly. We advised her about the lawful way to obtain an overseas divorce under the Family Law Act. Additionally, we ensured that the subsequent marriage complied with the stringent UK laws regarding the validity and genuineness of the relationship. With our vast experience in family and Ghanaian law, we ensured that she had the best chance of success. The outcome: spousal visa, granted within priority processing. The spouse visa was granted within priority processing timeframes, enabling the new couple to move forward with the marriage. This case illustrates how speed and knowledge of family and Ghanaian laws can be effectively leveraged in time-sensitive cases, particularly for dependents facing visa cancellation. Facing complex immigration issues? Contact BWF Solicitors today.
Well, I think I needed to prelude Uncle Charles's bit with that wonderful piece about BWF Solicitors, what they do, how far they have helped clients and all that. Uncle Charles, on that compliment, welcome again.
Thank you. Thank you. Thank you. Thank you.
Well, so lovely to have you with us again on the community and the law. Let me, on behalf of our numerous viewers and listeners, clients and friends alike, appreciate you for your time and the effort you put in to join us every Saturday afternoon when we are on the program, The Community and the Law. I salute you, sir.
I respond, sir. Pleasure.
Right, thank you very much. When you go to Ghana, from where I come, you greet a police officer. He says, I salute you, sir. I say, I take up, sir. Well, let me start off. I put the scenario to my viewers and listeners, and it was based on job offer withdrawn and whether people can have a claim. And it was based on the decision in the Kankana Lapali versus Loche Energy Systems Limited. And that decision confirms that accepting a conditional offer can still create a binding contract. Even if you haven't started work yet, the employer cannot simply withdraw the offer without consequences. And by explanation, yourselves, BWF Solicitors, have made us know that one may be legally entitled to notice pay. Conditions like references or probation may not prevent a contract forming, and withdrawal for internal or business reasons may not be lawful. So you have advised that if a job offer has been withdrawn, one could be entitled to compensation. I would ask you kindly to take us through this and open it up a bit more for us before we look at our scenario and see if we can advise our friend who faced a similar situation. Lawyer.
Yes, so we are looking at employment law in this instance, and employment rights are created once a contract is in place. An employment contract starts with the job offer and ends with the acceptance of the job offer, and whether certain conditions are met or not.
Okay.
Depending on the nature of the condition and how it is set out, the right may already accrue or not.
Okay.
And therefore, we are looking at when is that right accrued and under what circumstance, depending on how the conditions are couched out within the employment job offer, would there be a contract that cannot be easily retracted. So this is a case that, of course, has to be looked at on the basis that the court will make a determination whether this person will have a right or not. A job offer is made and somebody will have to accept within a time frame.
Okay.
Once you accept it, you accept with all the conditions. And once you offer with all the conditions. So offer and acceptance, that's contract. And because of the nature of the contract or the offer and acceptance and the circumstances, we say that the parties have intention to create legal relationship between them. And that becomes binding. So if a job offer is made and the terms are set out, some of the terms will have to be met before or met after the job offer has been accepted. The ones that ought to be accepted before, we call them condition precedent. And the ones that ought to be met after the acceptance of the job offer, we call them condition subsequent. So, if and within the employment right spectrum, you realize that the employer has a duty and the employee has a duty. The employer has a duty to ensure that the employee has right to work. The employee has a duty to provide to the employer right to work. So if you tell me, for example, that you need to provide your right to work, which is compulsory, you need to accept the job offer, we need to go through reference and clear them, you need to do your DBS and so on and so forth. You have to be clear which ones will have to be satisfied before the offer which is accepted can be binding. So where it is all mixed up and it's not clear, then the advantage will go to the employee. And so the employer must always clarify that these are the conditions. Regardless of when you accept the job offer, the contract cannot begin until everything A, B, C, D are satisfied or cleared.
Okay.
But when you say that accept and give, for example, your right to work, give us details of your referees and so on and so forth, and I accept and I give the details of the referees, then I assume that contract has been created.
Created, yeah.
Because even though the referees or the references will come later, you asked me to provide the referees details. And you didn't specifically say that the references or the referees will have to do ABC before the contract can start.
Okay.
What does it mean? It simply means that the employer must be clear that there is a proviso, and the proviso can only work once they are all met at a particular time, regardless of whether the offer is accepted or not. Then the employee will argue that you asked me to do ABC, I've done ABC, I've met the conditions as you specified, I have accepted the contract as you set out, and you asked me to report for work on this date. So if you decide not to continue, because contract has already been created, you have to give me notice of termination. And if you don't give me notice of termination, then you have something to answer at the employment tribunal as an employer. And the notice, again, if it is not satisfied, will be implied. If it is not, if it's not specified, what it means is that if it is not clearly stated, then it has to be implied. And by implication, we look at the standard expectation of general 3 months notice.
Now, on the nugget, you mentioned that withdrawal for internal or business reasons may be unlawful. For instance, if the offer was given at a date, and then we're saying that for some reason we want to postpone it, but then due to economic reasons, due to the fact that business may not have been as we anticipated. So we are not in the position to offer you that. Do we as an organization necessarily have to compensate the person the offer was made to?
So the contract will create what we call reliance. And reliance creates what we call legitimate expectation.
Okay.
And as a result of this legitimate expectation, the prospective employee, in this case, it's an employee because contract is already signed. This employee may have forfeited other opportunities. And so we are looking at the opportunity cost. The opportunity cost will be that because of this withdrawal or because of this job offer that I accepted, I have lost alternative offer, which I declined. And if you are telling me that it's no longer going to work, if I had accepted that, I would have legitimately gained something. So if you are going to compensate me, then you have to compensate me reasonably. And you can see that beyond even contract, we are looking at equity or fairness. If you are saying that you cannot continue and it is not my fault, then will you punish me simply by saying that we've drawn the contract, so go and look for another job? That's punishment, isn't it?
Yeah, obviously, because you haven't really properly managed my expectation.
Yes, and so if it's going to be withdrawn, then it has to be something legitimate. Example, the contract cannot continue because your references failed. That's legitimate.
Okay.
Your contract cannot continue because when we check your right to work, it shows that you don't have the right to work. Negative verification. The contract cannot continue because there is, for example, a law that prevents us from continuing to run this business.
Okay.
That is something beyond the control of the employer. And that might also be something contributed to by the employee. But where the employer just says that, you know what, we've changed our mind for internal reasons. Maybe the space is not big enough. Maybe somebody else that wasn't one of the workers who wanted to go didn't go. And that's why we recruited you. But, you know, there has been change of plans. So the person has stayed on. That's not a legitimate, that's not good enough. And so internal business reasons cannot suffice, legitimate, or justify the withdrawal of a job offer that is accepted.
Well, you may have issues like this. You may want to speak to a legal person, your law experts, BWF Solicitors. So contact them on 0208 493 7340 0208 493 7340 or 077 127 61884 077 127 61884. And if you have a question, you have a concern, you can put that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. As I mentioned, we have a very interesting and lively discussion we're going to have, and lawyer Charles Osma is going to help us to go into that. How do I meet the financial requirements for UK spousal application if I am self-employed? Now, check out the social media handles, and when we come back, we delve straight into the discussion. It's the community and the law. Brought to you by BWF Solicitors. Welcome back, and thank you for staying here with us. BWF Solicitors is a trusted partner when it comes to the law. Uncle Charles, yes, we're looking at spousal applications, and we want to consider the situation where the person is self-employed. Help us unpick this one and get a fuller understanding of it.
Right. So today we are looking at applications for spousal visas and the requirements for finance. So there is financial requirement for people who are employed, financial requirement for people who are self-employed, and financial requirement for people who are relying on their savings because there's no employment or self-employment income. Our conversation today is for self-employment purposes. And it says the requirement for spousal visa if I'm self-employed. So you are self-employed, you are sponsoring your application, or you are self-employed, you are using, or your wife or partner is self-employed and using their income from self-employment to show to meet the financial requirement. So within the self-employment rules, you have to show that your income, I will come to that income, that the income meets the requirement, and the requirement is 29,000. The 29,000, there are different incomes that a self-employed person will be having. A self-employed person will receive the money from customers or clients, and a self-employed person will pay expenses, and the self-employed person will pay tax, after which they keep the rest. So between the money received from clients or customers and the money left after the expenses, so the money left after the expenses is what you are going to pay your tax on. We call it profit. It is the profit that the self-employed person will show as financial requirement. So we have, as I said, money received. So let's assume that our self-employed, our client who is self-employed receives 50,000 from clients. This person spends 40,000 on business expenses. How much do we have left? 10,000. This 10,000 is the money that is left after expenses, and that is what a self-employed person will declare as income for tax purposes. And it is the same money that self-employed person will use for immigration purposes. And you realize that if it is for tax purpose and it is 10,000, you pay less tax. But then that 10,000 will not be enough for immigration purposes, because the standard for immigration purposes is 29,000. So between the declaration for tax and immigration, the tax man will see you to be working and spending and earning less profit. And so they will compensate you with less tax. But for the immigration caseworker, you are supposed to meet the threshold of 29,000. So if your profit is 10,000, that means you don't meet the standard. Yeah. What it means is that if this person who earns 50,000 is able to show 29,000, then expense should be reduced or managed up down to about 11,000, right? 11,000. So no, so 21,000. So what it means is that with that 21,000, if we add that to the 29,000, if we add it to the 29, it gives the 50. So if the expense is 21,
50.
If the expense is 21 and your profit is 29, then you pay tax on 29.
Okay.
And the immigration officer will say that you have met the requirement, because the requirement is 29. But the tax man will say that your profit on this occasion is more than the earlier profit of 10,000.
All right.
So it's gone up by 19,000. You have to pay more tax.
More tax. Okay.
And so to be able to show that you meet the threshold for immigration purposes, you have to show that you are paying more tax, because the more profit you make, the more tax you pay. What it means is that you cannot benefit on tax and benefit on immigration front.
Okay.
So with this 29,000, we are going to be looking at what is it that we have to show to be able to meet the requirements or the standard that the caseworker wants. We know how we got the 29,000, the profit. So if the person is making an application and the person uses 50,000, will the person meet the requirement or not? The 50,000 is the money from clients. Expenses have not been paid, so you cannot use the 50,000.
Yeah, because then
50,000 is not all yours.
Expenses could reduce the amount to less than 29,000.
And that is why they say that pay your expenses and let us know how much is left before we can show that you can meet your financial or maintenance when your wife or spouse joins you. Okay. Oftentimes, some people will use the 50,000, and that is obvious mistake. But that 50,000, which is the income from self-employment or turnover, includes expenses that are yet to be paid.
So, in effect, what we are saying is, if you are self-employed and you want to declare what it is that would come to you as your profit, then you would have to take away all your expenses and what a taxman would demand of you. Then what will be left would be what you can use to show to the caseworker that this is what my income is.
Yes, exactly. Exactly.
Okay.
So the taxman will want to know your profit, and the immigration caseworker also wants to know your profit. So the taxman is using it to charge you more tax. An immigration officer caseworker is using it to show that you meet the requirement for maintenance. And the two must be the same. And therefore, if the taxman, if you tell the taxman that your profit is less, and so your tax should be less, then the immigration caseworker will tell you that because your profit is less and it is not up to the 29, you don't qualify for the visa because you don't meet the financial requirements.
Okay. Right. So, from our previous discussions, lawyer, we know that people may support with some extra income from elsewhere, either in savings or a family member probably supporting. When you have declared your profit and it does not meet the threshold, can you get other sources to support this one so your application will be successful?
Right. So we are looking at the income or the type of income expected or that you can use. But remember, we said that we are dealing with self-employed people.
Yeah.
And with self-employment, it is self-employment. If it were to be employee salary, you can combine that of your wife or your spouse and yours. Unless, of course, both of you are self-employed.
Okay.
If both of you are self-employed, you can combine your profit, so to speak. But most of the time, the practice or the experience is that you have one person who is self-employed and their income is enough to cover the other person.
All right.
And you cannot mix the self-employment profit and the standard income from employment. So if you are using self-employment, you just have to declare enough, which is 29,000. If you are using standard employment income, then you can combine yourself and that of the sponsor.
Yeah. So the self-employed person, if they have savings elsewhere, can they fall on that?
So we come to the savings. Of course, you can, because the rules say that you can rely on savings. We'll come to the savings calculation. We did it the last time. But what we are going to do is to look at the documents that you need to provide to show that indeed you have ticked all the boxes for self-employment income for immigration spousal application purposes. And I'm sure after the commercial break, we're going to take all those documents, set them and put them so that we know how many and what they are and why you need them to meet that 29,000 or more for immigration purposes.
So get yourself ready, as Laura has prompted and preempted. We're going to pay our dues to BWF Solicitors. And when we come back, we're looking at further steps to take and how to meet the requirement. What documents you need to provide, what forms you need to fill, and what it is that you have to prove. It's all about meeting the financial requirement for a spousal visa application when you are self-employed. It's BWF Solicitors that's supporting us, so let's say thank you to BWF Solicitors, and we'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. As Lawyer said, we are going to look at some forms and documents we need to consider before we can successfully make that application. We're looking at how to meet the financial requirements for UK spousal application if you are self-employed. BWF Solicitors is proudly bringing us this one, and our resource person this afternoon is Lawyer Charles Asma. Uncle Charles, yes, let's move on to the next stage as you indicated.
Right. So we are looking at self-employment. I want to bring my wife. I want to bring my husband. I want my wife or husband to stay with me in the UK. They are switching from post-study work visa after their studies. They go post-study work visa. We are now married. My partner wants to switch to mine because I have indefinite, or I'm a British citizen, or I have an EU. I'm a EU national with 5 years or indefinite in the UK. I'm self-employed. My wife doesn't really work, and so I have to sponsor my partner. I'm self-employed. Because I claim I'm self-employed, I must have what we call confirmation of self-employment.
Okay.
And that confirmation of self-employment is a code. And that code is a tax code for self-employed people. And it is called Unique Tax Reference Number, UTR.
Okay.
The moment you register your business with HMRC, because you are self-employed, sole trader, you don't deal with the company's house. You deal with HMRC directly. HMRC will give you a letter specifying that you are due for self-assessment purposes, or you qualify for self-assessment. And that letter will have your tax code for the business. So they need that. And that is one piece of evidence that you are self-employed. So self-employment financial requirement, you have to prove that with your UTR, Unique Tax Reference Number, the original letter you received from the tax officer or HMRC. So that's ticked off. Because of this, you can file your self-assessment records, what we call self-assessment tax returns. You have to file it at the end of the year, and the year ends on the 5th of April every year. So for the year 2026 that we are in, because the year straddles, if there is an overlap, April to April or March to April. And because of that, in 2026, we are in May. So if you want to know the tax year, you say we are in the year 2025, 2026.
2026.
Yes. So that is the tax year 2025, 2026. So if you are going, if you want to um, sponsor, if I'm sponsoring my wife using my self-assessment records, I have to file my self-assessment tax returns for 2025. If I started somewhere in 2025, that means by end of the tax year, which is March of 2026, I would have been ending the tax year and I'm due for filing. So I have to file by April, May for what I need. But if I don't do it, then I have to wait till next year, January 31st. So I have 9 months after the end of the year to wait. But because I need it to support my wife's application, I have to file my tax returns. And once I file my tax returns, I will have what we call self-assessment tax returns record. That's from SA 100, from SA 200. So you have that. Once you fill all that online, you submit, you have a record of what you have submitted. That's the proof of your filing. Before you file that, you would have prepared your accounts. Your accountant would have prepared your accounts. So you need your accounts prepared, which helped you to file your returns. So you can't file your returns without preparing the accounts. So you prepare accounts based on the money. Remember, the money we are using is 50,000. My money was 50,000. My expenses was 21,000, and my profit is 29. And therefore, for my assessment, my accountant will put together my accounts. Income, 50,000. Expenses, breakdown, total 21. Profit before tax, 29,000. Then I will file the returns and the system will tell me the tax to pay. You don't have to worry about the tax. You just have to worry about whether the profit you are going to pay the tax on is equal to 29,000 or more.
29,000
or more.
Okay.
And so with that, I have the accounts prepared. My accountant who prepared the accounts will have to issue a letter, what we call accountant's report, confirming that the accounts has been duly prepared to reflect my income and expenditure for my self-assessment record. So now you see that you had your UTR, you had your accountant report covering the accounts, number 3, that isn't it?
Yeah.
Then, so we have UTR, your accounts, accountant report. Then you have the self-assessment tax record, tax return that you have filed or put into the system and printed a copy. Once you print a copy, or once you go through the system and you submit the returns, another record will be generated to show the tax you need to pay. We call it tax liability summary or tax calculation summary. And that is called Form SA302. So Form SA302 will show the tax calculation and the tax liability. So and that also showed how the tax was calculated. So if the immigration officer picks this as part of my wife's evidence or document, the person will see the profit based on which tax was calculated. And the person will say, that is fine, you meet the requirements. I don't have to pay the tax immediately because I have 9 months to pay the tax. So the question is not about whether you have paid the tax or not. The question is whether you paid the tax on the right amount of profit.
Okay.
And if it is not the right amount of profit, you have submitted the application. I have supported the application with the financial requirement evidence. However, the caseworker will refuse the application. And you know why? Why?
Because it's not the correct amount of profit you declared, based on which the taxman tax you.
Fantastic. Good. So from the analysis, the calculations undertaken, we know that the taxman is not really interested in what you tell him or her, but the immigration officer is interested in what you tell the taxman as your profit. So if you tell the taxman that your profit is what is required for immigration purposes, the immigration officer will accept it as such. But if you tell the taxman that it is less than what is required for immigration purposes, the officer will pick it and refuse the application and say that financial requirement was not met because the profit declared is lower than 29,000 threshold.
Okay. So you need your UTR, you need your account prepared, you need your accountant's report, and then you need the form 20 what?
Yeah, you need from SA 100, from SA 200. You just call it, you need the self-assessment tax return copy.
Okay. All right.
Tax returns that you have submitted, you need a copy. So you generate a copy and print it or download.
Okay.
Then
Okay.
yeah, please move on. What else do you need?
So you have satisfied the taxman.
And
You have
then,
satisfied.
you also have to show that you have satisfied the taxman. And what do you need to show to the officer for immigration purposes? That you correctly satisfied the taxman.
The taxman.
Tax calculation, isn't it? The
Yeah,
tax calculation summary.
Your accountant confirming that the calculation was done and submitted, accepted, and then the form that will be generated, or the evidence that you have submitted, will you generate that, print that one out, and add to evidence you're going to give to the immigration officer because they need all that to see and verify that you have met the requirement.
Good. So from this conversation, is it the accountant that will have to do the tax calculation, or it is the system that will have to produce the tax calculation based on the profit you have? Is it
Well,
manual
the accountant,
calculation or system calculation?
I think it is a system calculation that the Home Office would go with because then that will show that the taxman has accepted what your accountant brought and has verified.
Very good. And so if you just tell your accountant to do manual calculation, that is not verifiable because your accountant is not a taxman.
Yeah.
And so it's important. And that's why you have to print the tax summary. And it is on a form called Form SA302. And that will go with the self-assessment tax return that you have downloaded and printed. So these two from the taxman online. And the rest will come from the accountant. The accounts, the accountant report, and the UTR that the taxman will use to show that this is the tax you are paying for your business or for the self-assessment that you are filing.
Now, lawyer, one thing that I want to get clarification on is somebody is a sole trader, somebody is self-employed. What's the difference between that? And if there's any difference, would both have to go through these steps to satisfy the immigration officer that they meet the financial requirement?
Right. So now this takes us to business structures or business structure or legal identity of the business. So you can structure your business in any shape or form. The law allows it. And this conversation takes us into business law, not immigration law. So we have looked at tax law. We have looked at migration aspect of the tax. We are now entering the business aspect of this. The business law point is this. You start a business, and because you are different from the business, once you are not there, the business may survive or not survive.
Okay.
And the question is, are you the same as the business? If you are the same as the business, then the identity is linked to you. And we call it sole trader. Sole trader. That is what we call one-man business.
Okay.
One-man business. Sole trader, one-man business. So the one-man business, the one man does everything. The one man takes all the profit. And if the one man dies, the business dies. It's called sole proprietorship. And so with sole proprietorship, you don't deal with company's house. You deal with HMRC directly.
Okay.
So all you do is that you call HMRC. Hello, officer. I'm Charles. I'm a lawyer. In addition to that, I do law classes for people part-time. Yes. I received something. So I want to declare for tax purposes.
Okay.
All right. So you have told the officer that you are self-employed. You are running your own small business. And you are doing, so you've also told them what you do, tuition services. And in this case, you can be a barber, it can be any sole trader, self-employed. Then the officer will issue the UTR, the unique tax reference number, and at the end of the year, I'll put all my expenses, my income together. My accountant will do my report, add a letter to it, and I'll prepare my accounts for me, and I will use it to do whatever I have to do, including supporting my spouse's application for immigration visas. The next one, which is the second business structure, is partnership. Partnership is similar to sole proprietorship. The difference is that this time we have more than one owners. And they operate under what we call partnership deed or partnership agreement. And the deed or the agreement will tell the responsibilities and the rights and the commitment levels and the ratio for sharing profit. That is the agreement between the partners. There's what we call tax transparency. Tax transparency means that the business partnership itself doesn't file tax returns because it is not in any one particular's name. What it means is that because it's a partnership, each of the partners will file their own individual accounts based on the profit they received after sharing profit. We call it partnership. Again, the individual partners will file it as sole proprietorship, even though the proceeds came from partnership. So they will say, I received, for example, £50,000 as a partner of A and B partnership. And my expenses is this, and this is how much I am paying as tax or have as profit. Mind you, before profit is shared by the partnership, all the expenses would have been taken out. So this profit that I have, which is, for example, 50,000, my share of the profit, why will I also include expenses before I come to the profit again to be taxed? The partnership is there and everything goes into the partnership. As an individual partner, I may be incurring certain expenses which may only accrue to me. For example, as an individual partner, I may have to go on training, which will not go into the wider partnership expenses. I may have to upskill, I may have to upgrade, I may have to do certain things, I may have to do, and therefore I can attribute it to my line of profit. So then it becomes the second layer of expenses that will reduce my profit to the second profit for tax purposes. So if you are running a partnership and you are using your partnership income to support your spouse application to meet the financial requirement, you have to file your self-assessment tax returns because you still need a UTR, and the UTR doesn't go under partnership. It goes under individual partners' names.
Okay.
There's also another legal structure called limited liability partnership. So that is a blend of partnership sole trader and partnership limited liability company. The difference is that limited liability partnership, remember, it's all about liability of the business. For sole proprietorship, if the business collapses, all the liabilities of the business will be borne by the owner because you enjoy the profit alone, and so you bear the consequence alone.
It's alone, yeah.
For partners, once the business collapses, the liabilities of the business will go to the individual partners according to their partnership sharing, profit sharing ratio. So if my profit sharing ratio is, let's say, 50%, then that 50% will be my contribution towards liability if the business is in trouble. Now, you can see that again, it is attributed to the individual partners. But when it comes to limited liability partnership, because there's limited liability, once the partnership collapses or folds up or goes bankrupt, and we are trying to recover assets to pay the liabilities, we will not go to the individual partners to collect their TVs and cars and houses. We will relate to the limited amount they have committed to in terms of the registration with Companies House. So with limited liability partnership, it has to be registered with Companies House. And that provides what we call hybrid identity or business structure. And the reason is to limit liability. That's why some people opt for limited liability partnership. And if it's a limited liability partnership, I cannot, again, because it's a limited liability partnership, just for the liability, there's profit sharing. And that profit sharing, I have to receive mine. And again, I can file my return. And so for the limited liability partnership identity, we can have two: corporate tax identity and sole proprietorship tax identity for the partners. Does that make sense?
Yes, it does.
And we go to the fourth structure, limited liability companies. And that one, it doesn't really matter how many people are the owners. The ownership is the business itself. So the individuals who are behind the business are mere shareholders. And here, the business have what you call artificial identity separate from the owners. And the business becomes a going concern. And as a result of that, whether the owners are alive or not, the business will continue to be. And that's why most business people will prefer limited liability ownership identity for the business. So I've taken you through all the structures at that basic level. And that's the business law. We'll go back to immigration law because we are discussing immigration. And so for immigration law purposes, the caseworker assessing my wife's spousal visa application will want to see that, one, I have the UTR in line with the business structure. Profit has been declared and tax has been filed, and there is evidence that tax due is shown to be paid later. On that basis, I've ticked all the boxes and I have met the threshold if it is 29,000. If not, then my wife's application will be refused.
Well, the details have been spelled out. The conditions have been spelled out. What the taxman is looking for against what the immigration officer is looking for. But in all, remember, the threshold is 29,000. I know you may have some questions or concerns to put to Lawyer Charles Asma. This is a time to do so. So, with your kind consent, I'm going to activate the lines 0208-493-7345, 0208-493-7345, or if you have a text or WhatsApp, send that to 07399 208-468, 07399 208-468. And then you can leave the questions and concerns in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. Let me just remind you of our social media handles again. and welcome back. Thank you very much. Remember, you can put your comments in the comment section down below and we'll pick them up. And remember, we also have the scenario about our friend, the project officer, who put in an application, was postponed, and later on withdrawn. Ali Samba's application for a project manager role, as I said, was successful, and the employer sent him an offer later by email. This email said that the job offer was subject to receipt of satisfactory references, a right to work check, and a successful 6-month probation period, and proposed a start date of the 1st of April 2026. This our friend Ali responded that he accepted the offer and promised to sign and return the documents in a few days. He returned the requested forms, including copies of documents confirming his right to work in the UK. On the 15th of April 2026, as around 3 weeks before Ali was due to start work, the employer told Ali that it wished to delay his start date to the 3rd of July 2026. Ali replied, saying that he had already booked flights to the UK for himself and his wife, and asked what pay he would receive for April, May, and June. A few days later, the employer emailed Ali confirming that it was no longer able to offer him the contract for the position of project manager commencing the 1st of April 2026. The employer's reason for withdrawing Ali's job offer did not relate to Ali's failure to meet the terms of his conditional job offer. Rather, he withdrew the job offer for his own completely unrelated reasons. This man wishes to bring a breach of contract claim, arguing that the job offer had been withdrawn without giving him appropriate notice. What are his chances? Will he succeed or not? Think about that. We'll come back to this. But let's get to your questions. Remember, Lawyer Charles Asma is still here, and he will help us answer the questions that have come. Hello, Oreku and Mr. Asma have been given 60 days to leave the UK. Can get married to a British national within 60 days with, what if my 60 days has expired? Is it still possible?
Okay, so I've been given 60 days. Can I get married to Rose within the 60 days? What if my 60 day has expired? If the 60 day has expired, you're out of leave. And if you're out of leave, you cannot apply to remain with your spouse unless your spouse has a child that is British or has indefinite, or the child who may be an EU child or national with 5 years. But if you still have a visa or your 60 days is still in date, then you can apply to remain with your wife under spousal visa conditions. The question is what can I get married? Can I get married to a British national? Of course, if you have a wife and you are not getting married, why not? But you are not marrying because of visa. You are marrying simply because you love this person and you want to have a life together so that you can live together happily ever after.
Well, Alex, thank you very much for your question, and thank you, Lawyer, for the answer as well. Let's pick another one and put that to Lawyer to help us. Bianca Brown. A friend has a daughter with a British citizen man. At the time of birth, she was married to another man and refused for divorce. She has done DNA to prove that the man she was with at the birth of the child is the father of the child. What can she do now, Lawyer?
So, daughter with a British man, by the time of birth, she was married. And he refused. Okay, so no divorce yet. Now, she's done DNA, and it's for the man, the British man, I suppose. She was with at the birth of the child. Yes, so this is one of the complicated situations. The child can argue that, the wife, the lady can argue that this is the child, the father of my child. The British man is the father, or Susan is the father of my child. But the law will say that the father of your child is not a British man, but the one you were married to at the date of birth under Section 50, subsection 9A of the Nationality Act of 1981. And so it becomes a technical argument. The question is, this British man will also say that this is my child and I want my child. It goes to court, court says that this is your child, have your child. Then the child can apply to remain with of course, in this case, if the child was born while the father had the British citizenship, the child is British. And so the mother can apply to remain with the child as a parent of a British child.
I see the scenario. The divorce hasn't gone through. So obviously, the man in the marriage is technically the father of the child. And this person who is not technically the father of the child at the time is claiming that this is my child because I have DNA to prove it. The law will be on the side of the undivorced father, wouldn't that be?
As I said, that's the default position under Section 59A.
Okay.
However, so we have two fathers here. The legal father
and the biological.
You know why I'm laughing? The legal father. You know the legal statement. When you say the legal, it triggers other conversations. The legal father and the biological father.
Yeah.
So there's contention. Who should we give the child to if they're all fighting for the child and one has DNA to prove it? So one has marriage certificate to prove it. One has DNA to prove it. Who should we give the child to? And that is where equity comes in, emotions are at play, and common sense will prevail. And so it becomes contentious, isn't it?
Yeah,
a judge may hear the matter and say, okay, now, you know what? Well, if that's the case, this is your child, take your child. Now, because it's going through the court process and court has confirmed paternity on this man, this man becomes the father. And so, once this man becomes a father, the child can then say, this is my father. And the father's status can cover the child. The same way the one in the marriage can say that I also have marriage certificate to show. And so I am the father of this child. And so my status, which is 0, will cover the child.
But this is where the child technically is British.
Depending on what the court finally decides in terms of who has the final say to be the father.
The father, okay.
So the court says that you be the father, then, of course, once it is pronounced on this person, the child can then assume what the father has. And that is why in instances, if it is the other way around, if the other way around, where the British the citizen is the one married to the woman, and somebody else is married to them, somebody else had an affair with the woman, or the woman had an affair with another man and became pregnant. The child will be for the British citizen, right? By law.
By law.
Now, ordinarily, for immigration purposes, everybody will agree that if by law this is the father, then let him be. And so the child is British, isn't it?
Yeah.
Then we suppress the right of the biological father, because we are operating at the realm of the law.
Yeah.
But if the biological father also feels that, look, this is the only child I can ever have in the world, I won't wait or sit for the law to prevail over me. I will go and fight for my right in court with my DNA as evidence. Then it becomes contentious, and the judge will make a pronouncement who qualifies to be the father in the interest of the child.
Yeah, contention here. a difficult one, but yes.
Yeah, so our brother or sister who has a question, I think you have to have a conversation with the lawyer and let the lawyer look at the best way out for the child and yourself, if that is the case.
Bianca, yes. Speak to a lawyer, and I recommend maybe you speak to BWF Solicitors, speak to lawyer Charles Osma, and he will have a separate conversation with you and get into some details. Thank you, Kweku. If a British national has got a qualifying child, what are the requirements? Alex, I think, follows up with one he brought in earlier, lawyer.
If the British national has got a child, qualifying child, what are the requirements? Why? If the British national has a child, what are the requirements for what? The question is,
Alex brought in a question. Can we see if we can bring up his earlier question? Yes.
okay.
Been given 60 days to leave the UK. Once you get married to a British
So that's a
national within
follow-up.
the 60 days.
Oh, right. So now, so Alex, we have indicated that for spousal application, Alex may be beaten by time. Because by the time he studies the woman, by the time relationship takes off, by the time he goes through the marital processes and so on and so forth, I'm sure 60 days would have been over because that can take about a year plus, even though love is there. And so, if he has a qualifying child, he can apply as a parent. Oh, the British, oh, okay, says the British national. So in this case, once his visa has expired because of the 60 days notice, of course, he's living with a girlfriend, this one. He's living with a girlfriend and a child. He's living with them as a family. His visa has run out, but doesn't take away his role as a responsible man in the life of the woman and the child. Once they have the relationship ongoing, subsisting, eventually they marry, then because he's married to the mother of the child, he can apply as stepfather of this British child, and he will be granted leave to remain as a step parent of a qualifying child. If marriage is not what they prefer, then they have to stay together for 2 years to be able to qualify as de facto stepfather of this child. Otherwise, the third option would be to go to court and ask the court to grant you stepfather parental responsibility order so that you can play a role as if you are a father to this child. So these are the three options to prove that you have parental responsibility for the child. And as a qualifying child, you being the father of this child, you can apply to remain with your stepchild and your partner. And with this one, it doesn't really matter whether your visa is still valid or not. You can apply. The only difference is that you will be put under 10-year route instead of 5-year route.
Okay. Tilly Dumas, thank you very much for joining us. Alex gives us a thumbs up. Thank you very much. God bless you. And keep them coming through 07 399208468. You can call 0208-493-7345. Can EU dependent husband apply for a settled status 28 days to the 5 years? Or must it be exactly 5 years on the dot to apply, lawyer?
So you count the 5 years from the date you entered the UK or the date you married. The date you married, if at the time or date of marriage you were already resident in the UK. And if you are counting from the date you entered the UK, obviously you enter UK with 6 months. Within 3 months, you have to apply for pre-settled status and your visa will be granted within another 3 months, give and take 6 months. And so by the time your 5 years is about to, by the time you have had the 5 years residence in the UK from the date of entry into the UK, you still have your visa valid. but you don't have to wait because you would have had the 5 years already before the visa expiring. So the 28 days doesn't really matter. 28 days, I don't think 28 days will even be necessary because I gave you in the indication that if it is date of marriage, later you get your pre-settled status. 5 years pre-settled status, because you married before your pre-settled status application was made and you were issued with the visa in the UK, you don't need 28 days to be applicable. Your 5 years will be maybe expiring in 2027. But from date of marriage up to today is 5 years. Then you are due for settled status. Settled status. Or you enter the UK and 3 months later, you got your pre-settled status. That means by the time your 5 years is up, you still have about 3 months to spare on your visa. So either way, you don't have to bother about 28 days because it doesn't apply.
Let's keep them going through. Let's keep them coming over. Let's get lawyer to help us. Bafo Bonsu, please, my wife and I came to the UK in 2023 on a care visa, but our marriage is broken down for about a year and I moved out. Can I remarry after divorce if my dependent visa expires in October 2026?
So my wife and I came to the UK in 2023 on a care visa, but our marriage broken down 1 year and moved out. Can I remarry after divorce if my dependent visa expires October 2028? Can I remarry after divorce? Of course, you can remarry after divorce. But why would you introduce October 2026? Are you remarrying because of visa? If you are remarrying because of visa, then that will not be basis for marriage. And that's why I don't think October 2026 applies. So, but I think you need, just like our sister Bianca, you need to have detailed conversation, exploring all the background to situate your concern in context to offer you detailed legal advice.
And that will be given to you by BWF Solicitors, our trusted partners when it comes to the law. Visitors on the 4th floor of the other house, 214 to 218, Tottenham High Road, Seven Sisters in North London. The number to call, as you can find at the bottom of your screen, 0208 493 7340 or 077 127 61884. Remember, I've given you a scenario and I'll be expecting an answer from you, so think about that. But part right comes in with when you divorce your partner who is from EU and you retained your rights and you are due to settlement, how long does it take to receive your answer from the Home Office?
So, you divorce your partner, you retain your right, you due to settle, answer from Home Office. Oh, the whole story is about I've made an application and the retention of right. When will I get my decision? Isn't it?
Yeah, but you guys advise us not to hide anything from your lawyer.
I agree. So that's the crux of the matter. When will I receive my decision?
Yes.
But the decision is not dependent on, because the answer I'm giving is not dependent on the type of application made.
Okay.
Because the question is, I've made an application. When will I get my decision? It doesn't really matter what type of application, because the decision duration is not dependent on the type of application.
Okay.
They are standard. And so, yes, thank you, our brother, for giving us that extra information. But for applications, can be 6 months or more. I don't know when you made the application, and that is vital information. But you want to know when will you receive your decision. You should have told us when you made the application. And that's a vital information. Yeah.
Okay.
So tell us when you made the application. Then we can say that that is delayed indeed. You have to do ABC, or that is not a big deal, keep waiting. But at the moment, we don't know when you made the application, so we can't tell how long it's been. But the standard is 6 months or more. So if it is up to 6 months, wait a little while. If it is more than 6 months, maybe 7, 8 months, you have to start following up.
Well, Bob Wright, if you need any further help, contact BWF Solicitors. They'll help you. Okay, 0208-493-7340. I'll take the next one, and when we have had an answer, we will definitely go and look at our quiz and the scenario. Can someone stand on his stepdaughter to apply for further leave to remain? And if so, how does one go about it?
Yes, so you can apply as a step parent based on your stepdaughter. If your stepdaughter is a qualifying child, i.e., a British child, or a child with indefinite leave to remain, or a child who has lived in the UK for 7 years, or a child who is an EU national with 5 years, or a child EU national with indefinite, or a child born in the UK and has lived in the UK for 10 years. All these are qualifying children. How do you go about it? You said apply for FLR. FLR is not something you apply for. FLR is the whole category of application. So you are applying as a family member of your stepdaughter. In other words, you are applying as a parent based on your stepdaughter. And FLR is just an umbrella name for further leave to remain. But further leave to remain as what? So as parent, as spouse, as child, and so on and so forth, under my private life and all that. So in this case, as step parent. To do that, you have to prove that you are a step parent. You have to prove that you live with the mother of the child. You have to prove that it's a stepdaughter. So we don't know whether this person is he or she. So let's say mother of the child or father of the child. You have to prove that you play a role in the life of this child, such that if you are not in the picture, the child may suffer emotional harm and affect well-being and development. And the mother must agree, must confirm that you play a role. And again, there should be verifiable evidence to support the role you play, i.e., school letters, GP letter to support that. And if you have a visa and you're applying based on your child, and you want to apply under 5-year route, obviously, if you're applying based on your child, they'll put you on the 10-year route. So it doesn't really matter whether you meet the financial requirement or not. But the key things you need: relationship evidence that you are married to the woman, birth certificate that this is a child born to that woman or man. Then you need the profile of the child, school, GP, and relating to you, photos to show that you are indeed in the life of this child and all the things you do for the child. And you put in the application, you pay the fee, which is currently for £3,973, and you attend for fingerprint and you wait for your decision.
Well, and that brings us to the point where Citizen Kwejo has come up quickly with something. I will pick that one up because we're running out of time. We need to go and pick up our quiz and the summary. Fia is on a 5-year route under refugee status and is pregnant with K, who is on a 10-year parent route. What will be the immigration status of your child when it is born? Secondly, if either parent obtains their indefinite leave to remain within a year or two, is there anything they can legally do for their child to become British?
So let's unpack this. If you're 5-year route, refugee status. So the catch is refugee status. Pregnant with K, who is on a 10-year route. So K is a parent 10-year route. So he has 2.5. Ifia is 5. Refugee. What will be the immigration status of their child when the child is born? Okay, because the father has 2.5 based on his own child. this child cannot go under the child, under somebody else's, under the father's 2.5. Because in this case, the child will go under father's 2.5 based on the father's first child, through whom the father got 2.5. And this child will go as a sibling. But in that case, they have to be living together. But this child will not be living together with that child. And so the child cannot go under the father's 2.5. Then the only option available to this child is the mother's refugee status. And in this case, the mother will say that, well, I can't go to my country, and certainly my child cannot also go to that country. Can you attribute the same consequence I will face to my child and grant my child what you've given me? Second, if either parent obtains their indefinite within a year, oh, it's gone.
Yeah, we can bring it back, yes.
If either parent obtains indefinite leave to remain within a year or two, is there anything they can legally do for their child to become British? Once a parent has indefinite leave to remain, the child born in the UK, and I'm told this child was born in the UK, the child born in the UK will then be registered under Section 1, Subsection 3 of the British Nationality Act of 1981. And that law says that a child born in the UK whose mother or father becomes settled after the child has been born can be registered to become a British citizen.
Citizen Kojo, we're talking about British citizenship. That rhymes quite well. Okay, now let's quickly see what answers you gave me when I asked you to advise Ben Ali, or Ali Samba, so to speak, who had that dilemma. Would his claim succeed or not? Amachi says it will succeed. Who else has an answer for us? Lawrence Elizabeth says it will succeed. And we have Chris Asante saying it will succeed. Right, thank you, Chris. Francis Kuma says it will not succeed because the contract has not yet started. The next one is from Rex Wananabe, also thinking that Ali will not succeed because the contract has not yet started. We have Citizen Kwajo saying Ali will succeed because the employer had breached the contract. And the next one is from Daniel Ofusuhine, and Daniel says it will succeed. Let's pick up just one last one, and it's from Yasewa. Yasewa says it will succeed. Lawyer, will it succeed or not?
So let's unpack this. One, has a contract been created between Ali and this company? We are told that Ali Samba applied and got a job.
Yeah.
And an offer was made to him. He accepted the offer. And as part of that, he has to meet certain requirements. He has met some of them, the rest are yet to be met. Then the business or the company write to him to say that, you know what, we've changed our mind. We realize that we can't work with you. Of course, they wouldn't say that, but we've changed our mind, and it is for it's personal. They will put it like that. It's personal. That's what we mean by internal reasons. It's personal. So we are sorry. That is a breach of contract because the contract is not continuing, or the withdrawal is not because he has not satisfied the conditions. The withdrawal has happened because the business has chosen midway in this agreement to change its mind without any just cause. And because of that, our brother has been disadvantaged because he had legitimate expectation based on the reliance he placed on the contract of employment. And we are told that he was preparing to even relocate and so on and so forth. And all this have been shattered. And that is a drain. He has to be compensated because there is a breach of contract in this case. The reason for withdrawal is internal, not any legal or the fault of Ali. And so, what are the options? Ali will succeed because the employer has breached, Ali will not succeed the employer because the employer has not breached. And the answer is Ali will succeed because the employer has breached the contract.
So that's the verdict there. Thank you very much for that, lawyer, and for that explanation. We'll move on to the point where, by or by our tradition, let me put it that way, we pick up the summary of our discussion this afternoon. Lawyer.
Okay, so today's conversation was about financial requirement for spousal applications where there is self-employment activities. And we've understood that for self-employment activities, you have to show that you are self-employed, either as a sole proprietor or as a partner in a partnership business. Either way, you need a unique tax reference number from HMRC, and this will be on a letter. So it's very important. The next thing is for your accountant to prepare your accounts for you to show your income, the business expenses, and the business profit. It is the business profit that will be necessary for tax purposes. And so the accountant will use the business profit to file the tax returns, and the tax calculation will be generated by the system on a form SA302, based on which the person can show that this is the tax that they are liable to pay. The accountant should also prepare a letter or a report to cover the accounts, to show that the accounts has been duly prepared within the confines of the income and expenses of the firm, and they are whole, and also to say that the business is a going concern and that it will continue to operate and it will survive based on the profit levels declared. The accountant will issue that letter and sign. An accountant must be an accountant, and an accountant whose qualification is by a recognized accountancy board, i.e. ACCA, ICA, CIMA, and so on and so forth. And these 5 documents are vital. And the last bit I think we didn't cover previously is that you also need to show the basis of the income. And the basis of the income will come from the bank statements. The bank statement that the income of the business report on. And so if the account is a business account, then the business bank statement. If the account is an individual account because the person is an individual sole trader, then that statement covering 12 months. 12 months. And we know that 12 months is April to March the following year. So if the person is preparing to use it for visa purposes this year, then it has to be by the end of, it will be from next year, April, to this year, April, 12 months. And you have to add it to the document, making 6 key documents you need to show that you meet the 29,000 threshold. There was a question about savings. If you don't meet the self-employment threshold and you have savings, then the profit you have will be used to calculate the savings that you need. And the calculation formula is this: 16,000, which is the standard savings you have in your bank account, plus 2.5 times into bracket, times into bracket the profit you have, the difference between the profit you have and the 29,000 that you needed to have. So if your profit is 20,000, then it will be 29 minus 20, which is 9. Then 9 times 2.5. Half of 9 is 4.5. 2 times 9 is 18. 18 plus 4.5 is 22.5. So 22.5 plus 16 will give you 38.5, and that will be your savings to show to be able to meet the financial requirement for savings purposes. So that has been the conversation for this afternoon.
Though very technical, lawyer Charles Asma is breaking it down so very well for us to really understand. And remember, if you don't even remember anything at all, it has to be your 29,000 and your declared profit that the taxman has accepted and also verified. And that's what the Home Office will also be looking at. Lawyer Asma, thank you very much. God bless you. We appreciate your time. And as I said at the beginning of the program, we don't take it for granted at all that you have enough time to meet with us on the program, The Community and the Law. Let me also congratulate Helena Asma for winning the Employee of the Month of April 2026. And to you out there, thank you so very much for your time. People have stayed with us for 2 solid hours. That's so very encouraging. And others have also come in and gone. But remember, the link will be on our Facebook and YouTube platforms for as long as it stays there. So if you missed the live one, you can go back and watch. And of course, let people also know that we are here every Saturday between 4 and 6 p.m. I worked with Shilankra Padmododu. I'm a producer, Professor Adair. My name is Oreku Fripo. Thank you very much, BWF. Thank you to you out there. And I want to invite you to join us again same time next week. Until then, please be good. Enjoy the sun is out and have fun.